Today on Inside the Issues, I speak with David Estrin on the subject of climate litigation. Hello and welcome to this week's edition of Inside the Issues, a CIGI Online podcast. My name is Dr. Andrew Thompson. I'm an adjunct assistant professor of political science at the University of Waterloo and senior fellow here at the Center for International Governance Innovation. Every week, we're joined by an expert in global governance or international public policy. And today my guest is David Estrin. He's a senior research fellow here at CIGI with the International Law Research Program and an environmental law specialist here in Canada. David, welcome to the program.
Thanks very much. Glad to be here.
David, why don't we start? What is climate litigation?
Well, it can be different things to different people, but essentially the climate litigation that I've been much following and involved with people in the area focuses on trying to get domestic courts, a court in Canada, for example, or United States, to entertain a complaint by citizens in that country that their country should be doing something to reduce emissions, climate change emissions, or take actions to provide adaptation so that victims of those emissions that are already happening and occurring can be better protected. So it's citizens who are concerned that their governments are not doing enough to reduce emissions or not taking enough actions to protect them from the harm of climate change going to domestic courts.
Right. And are they targeting states or are they targeting corporations as well? And who is caught up in these cases?
Well, this new phase of, and indeed new genre of climate litigation that really began last year in Holland with the Urgenda case has so far essentially focused on governments. However, there are also some cases that are now targeting private corporations.
Right. And why is this happening now? I mean, you mentioned that this new line of litigation has really popped up in the last year. Is there an explanation for that?
Yeah, and in my just released paper, I try and get into why I think this is happening. And why I think it's happening is that it was back in 1992 that the world's nations decided to enter into the United Nations Framework Convention on Climate Change, which was signed and ratified in 1994. Since then, there have been, and in the convention, states clearly recognized that greenhouse gas emissions would end up producing dangerous effects for mankind and for the planet, and that these emissions needed to be reduced. It was a framework convention. It basically didn't provide roadmaps as to how that should happen. So for the last 22 years, every year, nations have been coming together at some usually nice place where political leaders and civil servants can gather to decide what they're actually going to do to try and bring down emissions. Right. And unfortunately, for the last 22 years, while there's been a lot of talk, the problem is that the emissions have only kept going up. Right. And citizens, therefore, have become increasingly frustrated with that. But why did they just get to the point of frustration and going to courts now? I think it's a combination of that growing frustration plus the now available clarity of climate science. The Intergovernmental Panel on Climate Change, the IPCC, which is a organization that's established under the umbrella of the United Nations and comprised of scientists from every country in the world, and they review all the science studies by other people. They issue reports, and before they can issue the report and reach conclusions, every word in it has to be agreed by all the countries. Wow. So it's the most dramatic example of a peer-reviewed type of report. Anyway, back in 2007 rather, they, for the first time, the IPCC warned that unless emissions were relatively quickly reduced, we would have the world's average temperature, the global warming, would increase by 2 to 4 degrees C above pre-industrial levels. And they indicated that that was something to worry about. Then the World Bank came out with a report after that called Turn Down the Heat, which basically, working with the Potsdam Institute, concluded that if we ever got to a 4 degree C rise in temperature above pre-industrial levels, we'd be, as someone put it, we'd all be grilled and roasted and toasted. And even 2 degrees C rise would be essentially very catastrophic in many ways for a lot of people. So basically, the world's nations knew as long ago as 2007 that they needed to actually get on with the action and stop talking the rhetoric about greenhouse gas emissions. And yet, they did nothing. They did nothing. They did sign up in Copenhagen or Cancun at one of these events in a nice place that they should bring down emissions. And in fact, the Annex I countries, the developed countries essentially, under the UN Framework Convention, agreed with the IPCC that they needed to bring down emissions themselves 25 to 40% by 2020 in order to keep the reductions that the IPCC was advising. They agreed to that. Even Canada agreed to that. Right. And yet it didn't happen. The emissions have still gone up. So coming forward to last year, 2015, in the case of Holland, for example, a citizens group there got organized, said, we got to do something. And they organized, this was the group called Your Agenda, which means urgent agenda. Right. And Roger Cox was a Dutch corporate lawyer who got concerned about climate change, took a real interest, started reading about it, worked with the group, brought a case, and successfully argued it last summer in the Dutch court of The Hague. And the court saw all the science from the IPCC. They heard the arguments. They saw that Holland had been one of those countries that had recognized that, yes, reductions of this nature were required, also recognized that Holland hadn't done it, and agreed that the Dutch government had a tort duty of care towards its citizens to actually take action to protect them from the harms of climate change. Of course, so that was the first and a unique victory on the climate litigation front from citizens.
Now, are the courts generally terribly supportive of this type of case? And I guess more specifically, is climate change something that is considered to be judiciable?
Well, those are important questions. The courts are not usually out to make waves. Right. They're generally conservative and want to follow precedent of some kind. And so the Urgenda case is quite a surprise and important because it is surprising as the first and important victory of this nature. But as we'll probably talk further on, there's been a few other cases since then which tend to show that other courts will be interested in this topic, and I can go into those reasons. But to answer your other questions, there have been previous cases about climate change litigation, for example, in Canada, where the federal court said, oh, that's not justiciable. We think it's too political. We don't want to hear it. Well, there was a case like that when, and sometimes courts who want to duck the issue can use that as an excuse to duck it. But that argument was actually made to the Dutch court, that court, you should not get involved in this. This is a policy matter for government. It's not the court's role to get into it. And the court quite clearly rationalized why it should. It said, look, people's lives and health are at stake. These are matters that are traditionally protected by the legal system. They have rights under the legal system. Right. The court's role is to determine whether or not those rights are being impaired and by whom, and to determine if there's an appropriate remedy. So we're not getting into government policy by determining whether people have rights that may be impacted by climate change, particularly if the government can control emissions. And that's the fact that in every country in the world has a legal capacity to control emissions within its own jurisdiction. I mean, the government of Canada could pass change in regulations under a piece of federal legislation that basically says no more greenhouse gas emissions in Canada by 2015 or 2020 or whatever. And of course, there's always economic implications, but the point is they have the control. And so so really what a court decides is in that context is whether there's a legal right and whether the court should provide a remedy.
Right.
And so the Dutch court said why it rejected the argument about justiciability. Another interesting argument made in the Dutch case that I think will always come up in these cases is, well, Holland's total emissions on a global scale are 0.5% of total greenhouse gas emissions. Your Honors, it wouldn't make any difference if you ordered the Dutch government to cut back emissions in the total scheme of things. And that goes along with their argument about why, this is just political and the court shouldn't do it. Right. And the court said, that's not acceptable. We don't agree with that argument at all. I mean, the fact is that the Dutch government can control emissions. They knew that back a few years ago, they committed to doing it because they understood there was a problem. And if they don't, it invokes the tort of hazardous negligence. So it doesn't matter. If every country took that view, then no one could be ordered to do anything. So they rejected that de minimis type of argument and said, government, you're going to do it.
Right. And as you mentioned, this is happening in other jurisdictions as well. And in your paper, you talk about a case in Bangladesh, a number of initiatives in the United States. Could you say a little bit about those cases and how they may differ from the Urenga case? Yeah,
well, the next major decision, not long after, really, Urgenda was about June of 2015. In the fall of 2015, a farmer in Pakistan went before a high court judge in Pakistan, and a judge appointed to the green bench, so they had special judges from the high court that would deal with environmental cases. And his complaint, the farmer's complaint, was that the government of Pakistan had recognized that it needed to provide a plan of action to deal with adaptation to climate change. Pakistan doesn't have that major emissions contributions, but it could have its population severely impacted by climate change, by melting glaciers or rivers drying up or all kinds of issues. And so they recognized they had to bring in a plan to deal with that. And they did pass a plan in 2012 or 2013, and the complaint by the farmer was government hadn't done anything. So he brought the case, and the judge, within 2 weeks of it landing on his docket, summoned 14 deputy ministers from various Pakistan government departments with any responsibility for environment before his court and said, gentlemen, the complaint here is that you're not doing what you said you would do under this climate change adaptation plan. Tell me about that. Is that the case? And so he heard testimony from them for a day. And at the end of that day, he said, well, gentlemen, so I think you're telling me that in fact you're not doing anything. You're not implementing the plan. Is that right? And they basically said, yes, Your Honors, unfortunately that is the case. So the judge then made a very eloquent decision saying, you know what, under the Pakistan Constitution, there are rights of people to life and to health. And previous decisions in Pakistan's Supreme Court interpreted the right to life as including the right to a healthy environment.
Right.
So the judge said, you know what, this is affecting constitutional rights. I have authority to as a constitutional judge to decide whether the Constitution is being breached. I'm concerned it is being breached in this case by the non-action of the government. I'm going to appoint a climate change commission who's going to report back to me on what they think can be done. And also I want the government to come back in my court in 3 months and tell me 3 specific things that they're going to do before the end of the year. This was in 2015. And so he invoked constitutional rights, which is different from the Dutch case, which invoked it's not common law, but tort law, which we also have in our similarities in Canadian common law. So that was very important. The judge really made eloquent statements about why climate change can impair constitutional rights. And it's a decision, I think, that will get a lot of attention. And most interesting about that is that the most recent aspect, the judge maintained a supervisory jurisdiction. So he heard back from the Climate Change Commission. And in January, they came back to him and said, you know what, Your Honor, the basic problem is that the Pakistan government and the local government, the provincial government, have not provided any money in their budget so that these agencies can get on with their job. The judge said, all right, I want a report back from the government I want them to tell me how much money they're going to put in their next budget on this issue, and I want to hear back in the next month or two. And he, in effect, ordered the governments to make sure there was appropriate money, he didn't say the amount, in their budgets to implement this, implement some actual steps. So this is really quite remarkable stuff. So that, and this is still going on, I mean, in terms of what it's going to do, so the judge maintains his jurisdiction. So then another important case is happening. There's a couple important cases in the United States, but the one that's really gotten to judgment already is one that's happening in Washington State, where children, through lawyers, are bringing an action against the state of Washington government, saying that the government owes them a duty as children who would be most susceptible in future to climate change, because the effects of climate change are going to be significantly larger in future than they are today. The government owes them a duty to revise its climate change emission rules to take their interests into account. And it's not good enough to just leave them as they might have been developed 10 years ago, 5 years ago, or even today, because those rules didn't take into account the worsening effects that would have on future generations. And so the first round in that happened last year, and the judge did find that under the state constitution of Washington State, there was a public trust duty on the government to act in the interests of protecting citizens from harm, protecting the resources of the state, which include water and air. And so the judge said, based on that, I think this department has a duty to revise its rules to take the children's interests into account. And I want to hear back from the department. So the department came back and basically said, well, we will revise the rule, Your Honor. And so the case was kind of in adjournment. And then recently, just in fact in April of this year, a motion was brought by the children's lawyers back in front of the judge. And the essence of it was the department had withdrawn whatever draft new rule it was thinking about doing, so there was nothing that was under its consideration. Right. And basically the complaint was, Judge, you really should not allow, you should now make an order specifically to the department that they must make a rule. The judge in her first rule had said, first order had said, well, I don't think I need to make a rule because I understand the government's going to act. So she withheld making an actual order, although finding the government had a duty to revise it. This time around, just a couple weeks ago, April the 29th, in fact, the judge said, you know what, I'm hearing these facts, this is a very urgent matter. She said, I'm going to vacate that portion of my previous decision where I said they didn't have to make an order. I'm going to order them to make a new ruling by the end of this year. And she said, why? She said, this is really urgent. She said, you know, the polar bears are being affected by climate change. People in Bangladesh are being affected by climate change. I can't do anything about the polar bears of the people of Bangladesh, but I can certainly do something about people in Washington State. I'm making this order right now from the bench.
Wow.
Yeah.
And maybe that's a good segue into my next question. I mean, is there a backlash, or is it conceivable that there could be a backlash towards this type of litigation, and that you will see critics that say this is judicial activism at its worst, or that governments may respond by making it more difficult for citizens to launch these cases in the first place?
Well, you can imagine that some people might want to take that view. First of all, if there are constitutional rights to a healthy environment, I don't think governments are well positioned to say the courts don't have a role in this.
Right.
And I think, for example, in Canada, should it come down to it, I think the courts in Canada are poised now to actually interpret Section 7 of the Charter of Rights, which provides for the right to life and security of the person as including environmental rights. Right. So I think that it's important. 100 countries in the world have constitutions that provide for a right to life, and many of them provide for a right to the environment. So I think many countries are well positioned to withstand that kind of an argument by invoking constitutional rights.
Right.
I think if governments don't want to have litigation against them, all they need to do is act on the dangers that they acknowledge at the United Nations,
Right.
act on the responsibility which we as citizens would like to think our governments would take to protect us from dangers that they agree are existing, and they're not doing it. So why wouldn't we go to courts, which are the place where we go when we have rights that are being impacted and no one's doing anything?
David, this has been absolutely fascinating. Thank you so much for being on the show.
It's my pleasure.
And thank you to our audience for tuning in. Please join us again for another episode of Inside the Issues, a CIGI Online podcast. Look for us online at cigionline.org, on Facebook, on YouTube, and on Twitter.